Oh, I had it open. Oh, okay. Just search for Mark Obenshain. He's got a live on parole issues. Okay. We're looking for your Facebook page.
Well, Tracy, it's good to see you. My name is Mark Obenshain, for those who are joining us on Facebook or on Zoom. I am State Senator representing the Shenandoah Valley. I am former chairman of the Senate Courts of Justice Committee and continue to serve as chairman of the Virginia State Crime Commission. And we are kicking off today a series of Facebook Live discussions and Zoom webinars in which we're going to talk about some of the issues that have come to light over the course of the past 30 days, in particular involving Virginia's criminal justice system, in particular parole. In mid-April, the case of Vincent Martin, who was twice convicted of the murder of Officer Connors, a Richmond City police officer, hit the news, raising awareness of really a frenzy of activity beginning in March by the Virginia Parole Board. It's a 3-member board that is appointed by governors in order to make decisions about parole of convicted felons who are in custody of the Virginia Department of Corrections. The publicity and the discussion has revealed what many believe to be a number of violations of law and violations of policies and procedures by the parole board itself, particularly a failure to notify victims, a failure to notify law enforcement and prosecutors of the decisions of the parole board, and also a failure to hold rescission hearings to consider the expressions of concern that have been expressed. Today, we're joined by Tracy Martin, who is the elected Commonwealth's attorney in Halifax County. And Tracy is here because a number of the inmates that have been released by the parole board have been inmates who were convicted in Halifax County of certain crimes. So Tracy, it's good to have you here.
Thank you for having me, Senator Obenshain.
Yeah, you bet. And Tracy, if you don't mind, since this is the first of our series of discussions on this, would you mind talking a little bit in general terms about who is eligible for parole in Virginia?
Sure, I can tell I guess the non-lawyers in the House, there are sort of 3 general categories. We've got pre-95 inmates who've been convicted of pre-95 cases, and they could be eligible for parole because parole was in place at that time. Of course, under Governor George Allen, parole was eliminated after that, and we went to something closer to a truth in sentencing process where prosecutors, defendants, judges, jurors had a better idea of how long someone would actually spend behind bars under any particular sentence, rather than that old antiquated parole system. But for those that are still in prison, based on the timing of those convictions, those folks could be eligible for parole. Then we've got geriatric parole, which is when people reach a certain age, if they have spent enough time in prison, then they might be eligible for geriatric parole. And then there's sort of a narrow category at this point of juveniles who might come up for parole after generally 20 years.
So the geriatric parole, and not to get too far down in the weeds, but my understanding is that if somebody has been convicted of a felony, is 60 years of age and has spent more than 5 years in prison, they will be eligible, or excuse me, 10 years. 60
Right.
years old and has spent 10 years in prison, or 65 years old and has spent at least 5 years in prison, they're going to be eligible under our geriatric parole. And anybody who's convicted before truth and sentencing before 1995 is going to be eligible for consideration for parole.
That's correct.
Okay. So, Tracy, my understanding is that you have a couple of inmates, a couple of folks who have been convicted of felonies for whom you've received notification that they came up for consideration in March or April of this year. And perhaps you could tell us a little bit about, first, about Deborah Scribner.
Okay. So Deborah Scribner was one of 3 individuals that were convicted of first-degree murder and conspiracy to commit first-degree murder of Eric Wynn. And then Ms. Scribner was also convicted of a related firearms charge with regard to those. So she was convicted of first-degree murder and conspiracy. She was sentenced to 23 years and 6 months. And this was just in 2012 that this occurred. And then she turned 65 in 2018. So she became eligible in 2018. She was reviewed, I believe, in 2019. Yes, sir.
Before we get into the parole process,
Sure.
Would you tell us a little bit about the crime itself?
Of course. Deborah Scribner was the grandmother of Dylan Wynn and the mother of Connie Wynn. Deborah and Connie, together with Dylan, plotted the death of Deborah Scribner's son-in-law, which would have been Connie's estranged husband and Dylan's father. The 2 women essentially arranged for Dylan to be the trigger man. Connie woke Dylan up in the middle of the night.
This is her grandson, right?
Correct.
And how old was he at the time?
15.
Right. So
15.
Grandmother essentially gets 15-year-old grandson to kill his father.
Right. Mother and grandmother got him to do that. He was 14 when they first started talking about this in front of him. And the need to get rid of him. Deborah Scribner had made efforts to arrange for a professional hit. It seems that she and Connie decided it was too expensive to do that, and it seems that they made those arrangements for themselves using their grandson instead. Connie Wynn woke Dylan up in the middle of the night, said, it's time. Can you still follow through with this? Deborah Scribner had given him the pistol that was ultimately used as the murder weapon. He took that pistol. He shot his father in the head. He and his mother and grandmother disposed of the body. Essentially, they dragged him off the couch. They wrapped him up in a blanket. They dragged him into a vehicle. They drove that vehicle across what I think is a family farm, and then they stuffed him down a well.
And having read a little bit of the brief, my understanding is that they literally had the grandson climb down the well to help drop the body. It's awful.
It's painful. Yes, I have a picture in my mind of apparently the body got hung up somewhere as on the way down, and the 2 women held a light and apparently made Dylan get in the well, and he climbed down there and had to push his father the rest of the way down. It's pretty atrocious.
And then in the aftermath, my understanding is there's no display of remorse on the 2 women's part. They even had a barbecue with the family's yard. I mean, it's
not that I'm aware of. No remorse that I'm aware of.
It's incredible. So she was convicted of what?
She was convicted of first-degree murder and conspiracy to commit first-degree murder, as well as use of a firearm in the commission of that murder.
And was convicted in what year?
She was convicted by jury in 2011.
And what was the sentence that was imposed?
23 years and 6 months total.
All right. So in 2011, she was sentenced to 23 years. So she shouldn't have gotten out until 2030, 33, 34, somewhere in there.
That's correct.
And when did you find out that she was going to be released?
I found out when I received a letter from the parole board on April 16th.
Connor, can you pop up that letter from the parole board? Is that,
Okay.
well,
Let's see, that's my letter.
I think that's your letter. Let's see.
There
Here we go. Is this a letter you received?
That is it.
So the letter you received came on April 6th. Do you know whether she was still in prison at that time?
I have learned that she was not. And let me just say, I think that there's been some effect on this pandemic of the speed with which our normally reliable U.S. Postal Service works. I didn't receive this letter until April 16th. But yes, it looks like the decision to grant her parole had happened on or before April 6th, according to the date of the letter. It does not tell me when she was released, but I learned later she was released on March 31st, before this letter was written or sent. So
there are a handful of things about this letter that are kind of disturbing. Number one, it's a form letter. I mean,
it is. In fact, I received 2 others exactly like it the same day.
My guess is it's not too hard to figure out who's the Commonwealth's attorney of Halifax County. Not
so hard, no.
The parole board, being part of the criminal justice system in the Commonwealth of Virginia, of which you're a part, I assume might even have access to your email address, or if not, maybe even your fax number.
I expect so, yes, sir.
But this was dropped in U.S. Postal Service and mailed to you as a form letter, Dear Commonwealth's Attorney. And this came to you after she was released. Is that right?
It seems so, yes.
So what's the law about notification of Commonwealth's attorneys? You can pull that letter off if you don't mind now.
But ironically, that letter cites the law and the code section that they're operating under when they send that. But the code section is very specific. It says that the parole board shall give 21 days notice prior to release of any granting of parole to the Commonwealth's attorney where the sentencing occurred.
All right. Now, I want to come back to that in just a minute, but is there also a requirement that the victims or family members of the victims be notified of the impending consideration of somebody for parole?
Yes, there's a statute that provides they are supposed to have advance notice. I believe it's 45 days before any parole decision is made. There's a process by which they're supposed to be included in a thorough investigation, and that's the language of the statute, that they're supposed to be notified that they're allowed to participate, that they can render either written testimony or in-person oral testimony, that the parole board shall consider their thoughts on it, and that they shall be heard before any decision is made.
Well, in this case, of course, the parole board followed the letter of the law in that regard too, right?
No, I'm afraid they did not. And I say that because any investigation, even something less than what normal folks might consider thorough, they would have found the only statutory victims in this case reside in Halifax County, but they did not send a notice to Kevin Wynn in Halifax County, Kevin Wynn being the brother of the deceased that law enforcement found at the bottom of that well in 2011. He was living in the same home that he's lived in for 20 years, including the time of the offense, including the time of the trial and the sentencing. He, in fact, had the same cell phone number as he did at the time, same P.O. box. Dylan, the grandson, so his nephew, had brothers who then would have been, they would have been minors, but are now statutory. They are victims. They are adults now. They live in Halifax County. It's, to my knowledge, no effort was made to reach them at all. And I learned quite after the fact that the parole board says that they sent a letter to a Kevin Wynn in Warrenton, Virginia. Mr. Wynn told me that he has never visited Warrenton, let alone ever lived there. So in terms of following the statute, in conducting a thorough investigation to try to find the victim, which I will point out is absolutely necessary for these older parole decisions. They didn't have electronic registration back then. I'm not sure if the parole board doesn't go through more effort to find someone who's easy to find, how they're going to find victims from 30 and 40 years ago when they're reviewing those parole decisions. It's a great concern.
Right. So if you found out after Ms. Scribner's release, is there any recourse available to you or the parole board in connection with perhaps an improvidently granted release, or a release that a parole that's been granted in violation of the law?
There's only one potential outlet, and it's governed by an internal parole board regulation, and it's called a rescission hearing. The parole board can grant a rescission hearing to reconsider a granting of parole. It's discretionary whether they do it. So in terms of, is there any real recourse? Is there any real appeal? No.
Well, and I will tell you, Tracy, that I have spent a good bit of time over the course of the past month myself talking with you and your colleagues, other Commonwealth attorneys around the state. I've learned more about our parole system than I ever thought I would know. And that's not a good thing, but I will tell you that what I've learned is that the rescission hearing is something that is quite regularly utilized. And frankly, the notice to Commonwealth attorneys comes typically after a decision release has been made, and the Commonwealth attorney may provide the parole board with additional facts that they did not consider in connection with their grant of parole, or corrections officials may notify the parole board of some violation of the rules or violation of the law that has occurred. And the parole board absolutely has the power, the right, and the ability to hold a rescission hearing and change its decision. And my understanding is that those have even occurred after the release of inmates. And so in this case, did you ask the parole board to utilize that power?
I have asked, and I have not heard in either the Clark case or the Scribner case a definitive answer.
So so my understanding is that Deborah Scribner is not the only violent felon or murderer from your jurisdiction who has been granted parole within the last 60 days. You
Correct.
have another case?
I do. We do. It's Robert Kevin Clark was convicted of capital murder, robbery, and 2 related firearms offenses. He was given, a jury recommended and a judge followed that recommendation. They imposed 2 life sentences for capital murder, for robbery, and then an additional 6 years for the firearms violations. And
this was a pre-1995 conviction, is that right?
It was in 1994.
Okay.
So we are somewhere between 25 and 26 years that he would have served.
So is he a geriatric guy? Would he qualify for geriatric release?
He would not. I believe he's 45.
And my understanding is, am I right that this, the shooting involved arose from maybe a petty dispute? And
it seems so, yes.
And shot a victim. Can you tell us a little bit about
Sure.
Real briefly, we're running out of time, but about the facts.
Yes, the victim came down from Northern Virginia. He had a social contact or a business contact, depending on who you talk to, with Mr. Clark and a co-defendant. Mr. Clark and the co-defendant ultimately together shot the victim at least 12 times in the head, again, over a low-level debt, and it seems. And I don't know that anyone ever truly knows why these things happen, but that seems to be the motivation in the record. But yes, it was a horrendous crime. They stole from him afterwards. They tried to dispose of his belongings, burn his clothes and his wallet and so forth. Ultimately they absconded. They hid away in New York, I want to say, for more than 30 days before they were found. And then they were both convicted of the crimes.
So Tracy, were you or the victims notified prior to Mr. Clark's release?
I was released I was notified prior to his release. He was, I learned, scheduled to be released on May 4th. Let's see, I was notified, I think the letter is dated April 10th. I believe I received it somewhere around the 18th. I think he's still in, has not been released yet, as far as I know. And again, I have not heard on whether or not I've been granted or denied my request for a rescission hearing in his case.
And let me ask you, these folks who are eligible for consideration by the parole board for parole, they are considered every year, which means that if in March or April of 2020, these two inmates were granted parole, that means that in March or April of 2019, they were also considered for parole. Do you know what happened in 2019?
In both of these cases, they were denied.
Do you know why?
They were denied because I'm not sure the reasons. I'm sorry, but they were not found to be appropriate under the discretion of the board, which I think was the same, as far as I know, as it was this year when they came up for parole.
Yeah, and my recollection, and I'm taking a quick look, you know, the parole board, interestingly, they post on the parole board's website a list of everybody they consider for parole, and they publish on that website the reasons why parole are denied. And for Deborah Scribner, it said that in 2019, release at this time would diminish the seriousness of the crime, serious nature and circumstances of your offense. So between 2019 and 2020, do you know of anything that would have changed those considerations and rendered
Absolutely
her more
nothing.
appropriate for release?
No, absolutely nothing changed. The only change would be she had served 9 years instead of 8. It's just offensive on a 23-year, 6-month sentence with these victims and the nature of what she did.
Well, Tracy, anything else you want to say before we sign off?
I'll just, as far as I think we need help. We need a legislative fix. The communities from these crimes came out of need help of you and those like positioned. You know, I'll make a cry out for transparency. Right now, you go on the parole board site, it is very difficult to tell what crimes each of the those that are considered for parole have been convicted of, what jurisdiction they're in. It's very difficult and takes quite a bit of research to pull that information. And of course, you're not given reasons for why someone's granted parole, only if they're denied. I mean, all of these things should change. Also, I'm not sure there's any justifiable reason why a Commonwealth's attorney shouldn't be part of a thorough investigation or contact of the local victim witness coordinator, who in the case of Deborah Scribner was the same person as was in place when Eric Wynn was murdered. I mean, these are things that I think we took for granted occurred before, and at least we had a rescission hearing available to us, even though we were notified after a decision, but before release. But really, we can't represent the best interests of the locality without being able to participate in the process. And we've been effectively, because of this parole board's decisions, been cut off from that.
Well, Tracy, thank you very much for joining me today.
Thank you for asking me.
Yeah, this is an incredibly important issue. It's not a partisan issue. It's something that Republicans and Democrats and independents came together on back in 1995 and crafted a bipartisan solution to what was a really serious problem in Virginia. The problem is not going to be solved by simply going back to the old system. And tomorrow we have Commonwealth's attorney Phil Ferguson from Suffolk, who's going to be joining us and further demonstrating the bipartisan issues here. Phil and I have shared different political labels, but the same policy concerns about this. And I want to make sure that people understand, Tracy, that this is not a partisan issue. This is an issue that really involves the safety of our communities and appropriate principles of crime and justice, and frankly, making sure that victims and law enforcement and the interests of justice are taken into consideration in these important decisions. So thanks for lending your voice. You've been an outspoken member of the law enforcement community over the past month and have done an awful lot to raise the profile of this issue and to highlight these issues. So thanks again.
Thank you. Thank you. I hope we can, this should not be a partisan issue. It's my sincere hope that we can all agree that those convicted of the worst violent crimes are probably best sent in prison. But I'm surprised that it's become a partisan issue. I'm an independent, but I feel like everyone in law enforcement, no matter what their party affiliation, can agree on that. So I would hope that our General Assembly could as well.
I don't think it is, and I don't think it has become a partisan issue. I think talking about it is an important way to keep it that way. So thanks again, and
thank you.
Hope you'll join us tomorrow. And so we talked to Phil, and for the rest of the week, I'll tell you, we have George Allen coming on Wednesday, who was the architect of the bipartisan truth in sentencing policy. And then on Thursday, we have Stacey Garrett, who was the line prosecutor in the city of Richmond, who prosecuted the case involving the murder of Officer Connors there. So in any event, thanks to everybody for joining us, and we'll be back tomorrow.